Hey everybody, Bill Sack here, the most mediocre pistol shooter on the Firearms Policy Coalition legal team. This week, my hero and yours, FPC Director of Constitutional Studies Joseph Greenlee, filed yet another Supreme Court amicus brief, this most recent in the case of Flick v. Wilkinson. You see, the Gun Control Act states that a person convicted of a felony, and even some misdemeanors, is forever stripped of their Second Amendment rights. Under 922G1, the nature of the crime is immaterial. In other words, the offense can be something as heinous as murder, or as innocuous as opening a bottle of ketchup and putting it back on the shelf at a supermarket in New Jersey. Seriously, that's a thing. As such, the law casts an exceedingly wide and potentially unconstitutional net. In 1987, Kenneth Wilkinson was convicted of criminal copyright violations for importing counterfeit cassette tapes. As a result, under federal law, he's prohibited from owning and possessing firearms and ammunition for the rest of his life. So what does selling counterfeit Depeche Mode tapes have to do with your right to defend yourself, you may ask? Well, as far as we're concerned, not a damn thing. And as our recently filed brief makes clear, there is simply no historical justification for such a broad and undiscerning disenfranchisement. You can read the entire brief and stay up to date on all of our other critical work, including the recently filed cert petitions in Holloway and Falajatar, which argue this same exact issue, at fpclegal.org. I'm Bill Sack, the most mediocre pistol shooter with the Firearms Policy Coalition legal team.